Welcome to SQE1 Preparation, Criminal Practice, the police interview from the police's perspective by Street Lawyer, helping you to pass first time. The FLK2 Criminal Law and Practice states this about procedure for interviewing a suspect under PACE 1984. And I've done separate classes on solicitors' conduct issues at the police station and solicitors' role at the police station. So what is covered in this class? To understand the procedure centred on the police interview from a police's perspective, should a suspect be interviewed at all? Can a suspect be interviewed before receiving legal advice? And I'm going to look at the general position and then the 4 exceptions or situations when a suspect can be interviewed without a solicitor. What should happen at the start of the police interview? When must an interview cease? And what are the consequences if the police do not follow the correct procedure? By way of SBAQ tips, these could centre on the rank of officer who can authorise a police interview without a solicitor, whether an adverse inference can be drawn in a situation where an interview takes place without a solicitor, which caution should be given, and about what are the consequences of not following the correct procedure when carrying out a police interview under caution. There's a couple of test your knowledge questions here. Test your knowledge question 1. A suspect, having been given his rights, asks for a solicitor, but then later changes his mind. The custody officer authorises the interview to proceed in the absence of a solicitor and makes an entry into the custody record. The suspect also confirms in writing they no longer want legal advice. And the question is can the police interview continue? And you've got A, yes, and B, no. Yes is because written authority can only be given by an officer not below the rank of custody officer, and B, no, because written authority can only be given by an officer not below the rank of an inspector. Then you've got test your knowledge 2. Can the police insist on carrying out a police interview under caution of a suspect who is sober but cannot speak English? Answer A, yes, or is it B, no? Test your knowledge 3. A suspect who has previously indicated they do not want legal advice changes their mind during the police interview room. What should the police do next? Is it A, remind the suspect they were given the chance to receive legal advice but declined the right and continue with the interview? Or is it B, stop the interview and arrange for the suspect to receive legal advice? Test your knowledge 4. A suspect asks for a particular solicitor, but the solicitor cannot be contacted, and the suspect has then declined the opportunity to consult the duty solicitor, Code C, paragraph 6.6c. Who can authorise the interview to continue, and can an adverse inference be drawn should the suspect decline to answer questions? And the answer is A, or is it B, or is it C, or is it D? A, authorization from an inspector, no adverse inference can be drawn. B, authorization from a superintendent, no adverse inference can be drawn. C, authorization from a superintendent, adverse inference can be drawn. Or is the answer D, authorization from an inspector, an adverse inference can be drawn. Test your knowledge 5. Which caution should be given at the beginning of the police interview where a superintendent authorizes a suspect's delay in receiving legal advice? Is it A, you do not have to say anything, but anything you do say may be given evidence? Or is it B, caution, you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court? Anything you do say may be given in evidence. And then final test your knowledge question, test your knowledge 6. Tony confesses to the crime with which he is subsequently charged during his interview under caution with the police. At trial, Tony will claim that the only reason he confessed was because the police repeatedly asked him the same question over the course of the lengthy police interview. Disregarding his denials, during his interview he received no refreshments or breaks and was not offered access to a solicitor at any time whilst at the police station. The prosecution do not deny the confession was obtained in the manner described. Will the prosecution be allowed to adduce evidence of his confession at the accused trial? Is the answer A, yes, or is it B, no, or is the answer C, no? Is it A, yes, because the confession is relevant to the matter in issue in the proceedings and so can be given in evidence against the accused regardless of the manner in which it was obtained? Is it B, no, because the confession is hearsay evidence, it is not admissible at a criminal trial without leave of the court. Or is the answer no? No, because the court must exclude confession as it was obtained by oppression. So now we go into the various questions and the content of this class. Question: what is an interview under caution? An interview is defined in paragraph 11.1a of the Code C as the questioning of a person regarding their involvement or suspected involvement in a criminal offence or offences, which under paragraph 10.1 must be carried out under caution. Question: should a suspect be interviewed at all? Basically, is the suspect fit for interview? An interview should not take place if the suspect, who at the time of the interview appears unable to A. appreciate the significance of questions or their answers, or B. understands what is happening because of the effects of drink, drugs, or illness, ailment, or condition, should not generally be interviewed. There are some limited exceptions where an interview needs to be held as a matter of urgency, and you can see Code C paragraph 11.118 subsection B. Can a suspect be interviewed before receiving legal advice? Well, there's a general position and then there's exceptions. So let's look at the general position first. The general position is a suspect should not be interviewed or continue to be interviewed until they have received legal advice. This means 1. The police should not seek to interview a suspect who has indicated that they require legal advice, or 2. Where a suspect has indicated that they do not require legal advice, is then interviewed and indicates at some point during the interview that they have changed their mind and now require legal advice, the police should stop the interview to allow the suspect to obtain advice. Can a suspect be interviewed before receiving legal advice? Now, there are 4 exceptions, and you can see them 1, 2, 3, and then there's 4. The first one is police delay. Section 58A allows the police to delay a suspect receiving legal advice for up to 36 hours, and that is where the grounds exist. Authorization must be by a superintendent. In that situation, adverse inferences cannot be drawn, and I've done a separate post about the grounds of delaying legal advice in another class. And then you got 2, solicitor delay. If the relevant solicitor has agreed to attend the police station but awaiting their arrival would cause unreasonable delay to the process of investigation, then authorized by superintendent, an adverse inference cannot be drawn, an interview can proceed. And then the third one is solicitor issues. If the solicitor the suspect has asked to speak to either cannot be contacted or has declined to attend the police station, and the suspect has then declined the opportunity to consult the duty solicitor, the interview can continue if authorized by an inspector, and an adverse inference can be drawn. And then the final one is change of mind. This one's a big one. The detainee changes their mind about wanting legal advice, or as the case may be, about wanting a solicitor present at interview, and states that they no longer wish to speak to a solicitor. In these circumstances, the interview may be started or continued without delay, provided that, and then you've got a couple of conditions there. One is inspector of the rank of above needs to speak to the detainee to inquire about the reasons for their change of mind, makes or directs the making of reasonable efforts to ascertain the solicitor's expected time of arrival, needs to sign an entry to this effect in the custody record. The officer, inspector rank and above is satisfied that it is proper for the interview to proceed in these circumstances. And then you can see bullet point under 4 gives authority in writing, and then bullet point 2 under that is takes or directs the taking of reasonable steps to inform the solicitor that the authority has been given and the time when the interview is expected to commence, and records or causes the recorded the outcome of the action in the custody record. In essence, try to make a call to the solicitor. And then you got number 5, when the interview starts and the interview reminds the suspect of their right to legal advice. The interview shall then ensure that the following is recorded in the written interview record of the interview recorded, or the interviews recorded made in accordance with Code E and F. And then you can see the various points there, what the police officer needs to do. Confirmation that the detainee has changed their mind about wanting legal advice, or as the case may be, about wanting a solicitor present and the reasons for it if given. The fact that the authority for the interview is to proceed has been given, and subject to paragraph 2.6, the name of the authorising officer. Bullet point 3 is that if the solicitor arrives at the station before the interview is completed, the detainee will be informed without delay, and a break will be taken to allow them to speak to the solicitor if they wish, unless paragraph 6.6a applies. And then you've got the final one, is that at any time during the interview the detainee may again ask for legal advice, and that if they do, a break will be taken and allow them to speak to the solicitor, unless paragraph 6.6a, b and c applies. And you can see an adverse inference can be drawn. Another question is can an adverse inference be drawn at trial if the suspect is silent at police interview? And you can see there's a summary of what I've just said. 1, police delay. 2, solicitor delay. 3, solicitor issues. And 4, change of minds. And you can see when an adverse inference can and cannot be made. What happens at the start of the police interview? Which caution should apply? Well, when it comes to exceptions or situations 1 and 2, police delay or solicitor delay, the caution is you do not have to say anything, but anything you do say may be given evidence. And you got general position and the exceptions of 3 and 4, where there's solicitor issues or change of mind. Well, the caution is going to be you do not have to say anything, but it may harm your defence. If you do not mention, when questioned, something which you later rely on in court, anything you do say may be given in evidence. And the next question is what should happen at the start of the police interview? Well, the police have got to give the correct caution, as mentioned previously, explain the suspect's continuing right to legal advice. The police officer must also put forward any significant statements or significant silence, and you can see what the meaning of significant statement is and significant silence is. A significant statement is a statement which appears capable of being used in evidence against the suspect at trial. In particular, a direct admission of guilt, e.g. I was at home at the time. And then you've got significant silence, a failure or refusal to answer a question or to answer satisfactorily when under caution, which might allow the court to draw an adverse inference from that silence at trial, e.g. where were you, and the person says, and the person remains silent. And then you got a question here is what would amount to an oppressive police interview? And this is taken from the law. No interviewer may try to obtain answers or elicit a statement by the use of oppression, and that's in Code C 11.5. Oppression might occur if the interviewing officer A raises their voice or shouts at the suspect, B makes threatening gestures towards the suspect, C leans towards the suspect so that they are in the suspect's face, so to speak, D stands over or behind the suspect, or E threatens to detain the suspect indefinitely unless they make a confession. Question is, can the interviewing officer offer any inducements? The answer is no. Interviewer shall indicate, except to answer a direct question, what action will be taken by the police if the person being questioned answers questions, makes a statement or refuses to do so, and that's in Code C, paragraph 11.5. This means, in effect, that an interviewing officer must not offer any inducements to a suspect to admit their guilt. For example, if an interviewing officer indicates to the suspect that they may be released from police detention much more quickly if they admit to the offence. And then you got another question is, when must an interview cease? And you got 4 bullet points there. A police interview must cease in the following situations: when the officer in charge of the investigation is satisfied all the questions they consider relevant to obtaining accurate and reliable information about the offence have been put to the suspect, and this includes allowing the suspect an opportunity to give an innocent explanation and asking questions to test if the explanation is accurate and reliable, e.g. to clear up any ambiguities or clarify what the suspect said. Another situation when an interview must cease is if the officer in charge of the investigation or in the case of a detained suspect, the custody officer reasonably believes there is sufficient evidence to provide a realistic prospect of a conviction for that offence, and that's in Code C, paragraph 11.6. So the first one relates to the officer in the case. The second bullet point relates to the custody officer. The third one is if interviews with a suspect takes place over more than one day in any period of 24 hours, the suspect must be given a continuous period of at least 8 hours for rest. This period will usually be at night and must be free from questioning or any other interruption in connection with the offence. That's Code C, paragraph 12.2. And then the final one, when it must cease, is similarly breaks from interview should take place at recognised meal times, and short refreshment breaks should be taken at approximately 2-hour intervals, and that's Code C 12.8. What would amount to a breach of PACE interview? Well, you've got a couple of examples here. Forgetting the caution. Police officer forgets the issue to give the caution at the beginning of the police interview, gives the wrong caution. Forgetting to put forward any significant comments by the suspect. Forgetting to put forward any significant silence by the suspect. No breaks in interview, offering inducements, or some form of oppressive questioning, repeated questioning, for instance. Question is what are the consequences for breaching PACE? Well, you've got Section 78, which is the main section here of PACE, Police and Criminal Evidence Act, and remember the word is may. Section 78(1) says, in any proceedings, the court may refuse to allow evidence on which the prosecution proposes to rely to be given in if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. So in the context of where there are breaches of PACE in and outside the police interview, any comments made by the suspect during the police interview may result in any responses made by the suspect in the police interview or the significant statement and silence being ruled inadmissible as per Section 78. What are the consequences of breaching PACE? Section 76 of PACE, and this is, remember the word is must here. Section 76(2) PACE, if in any proceedings where a co-accused proposes to give in evidence a confession made by an accused person, it is represented to the court that the confession was or may have been obtained by oppression of the person who made it, or in which was likely in the circumstances existing consequences of anything said or done at the time to render unreliable any confession which might be made by him in consequences thereof. The court shall not allow the confession to be given in evidence for the co-accused except in so far as it is proved to the court on the balance of probabilities that the confession, notwithstanding that it may be true, was not so obtained. Any confession made by the suspect obtained by oppression or as a consequence of anything said or done must therefore be ruled inadmissible. Now we return to the test your knowledge questions. Pause the recording, check the answer. Again, pause the slide and check the answer. Again, pause the slide and check the answer. Test knowledge 4, again, pause the question, check your answer. Again, test your knowledge question 5, pause the slide and check the answer. And then with test your knowledge question 6, again, pause the question and check your answer. And then remember, with all of these classes, watch this video again. It's been a long one. Watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book. attend and participate in the classes, prepare your own Q&A flashcards, practice as many SBAQs as possible. Don't forget to subscribe to Community Legal Education and put your notification on so you don't miss out on more SQE prep videos. I really do hope you found this class useful, whether you're a law student or just somebody who's curious. See you in the next class, and thank you for watching.